going on? How's everyone doing?
Shout out to everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Thanksgiving. I hope you and your families all have a great day today. Stay safe. Don't do anything dumb. You do not want to make it onto my channel. All right. Had to get the little disclaimer out of the way. I have got a great one for you. Now, the excitement isn't really there. It's the charge that what he's charged with is going to blow your mind. And it is, I couldn't help from laughing. I really couldn't. I try not to laugh during court cases, but it's really hard not to. This guy is in jail, and his girlfriend decided to do something to him during visitation hours in front of just about everybody else in the visitation room. Yeah, this happened. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
In case number 24S19032FC, People v. Desmond McClure. Defendant is present in person, as is attorney Mr. Franklin, is the officer for sentencing. I have those copy of the.
All right, Mr. Franklin, have you had an adequate opportunity to read the pre-sentence report and the sentencing information with your client?
Yes, Your Honor. At this time, there's no additions, deletions, or corrections.
All right, with accurate information on which to base sentencing, I'll turn it over Mr. Butler. Anything on behalf of the people?
Your Honor, this case is presented to you through a bench trial conviction. You're very familiar with the facts of this case. This has a considered recommendation for the court.
Okay, Mr. Franklin.
Thank you, Your Honor. So the recommendation here is for 2 years, 24 months. So look at the face sheet, what we see is it's 2 to 34. I would ask the court to go more towards the middle of the guidelines. The court did hear this case. And, you know, there are some interesting facts. I think Mr. LaFleur's got some things to explore if he wants to go the appellate route, whether someone in MDOC can consent to what happened here or not. I think is interesting. I want to know the answer to that question. But more than that, I mean, what the court's really getting at here is you've got someone who's been in prison for a long time and feels the warmth of a woman's touch, sits there and does nothing. I think without more, it's understandable. Oh, it's still wrong. I mean, that's why we're here. We can understand what's going on in his mind. And this court has made it clear they start middle of the guidelines. There was nothing presented to show that he did anything more dastardly that would move the court beyond. So that's what I would ask the court to do, is just set the sights on the middle of the guidelines.
All right, Mr. LaFleur, anything that you want to say before the court imposes a sentence?
Step on the right, attorney, so I'm not sure doing it right.
All right, I am going to give you a quick heads up. This comes really close to a sovereign citizen type argument. It's not. He's just citing Supreme Court rulings that have nothing to do with his case. Well, they have some relation to do with this case, but it's you'll hear it, and he gets close. So I'm going to say sob sit adjacent, but at least he's in the right ballpark. He tried. Let's just say that he tried.
Yeah, I just want to say, like, me and my attorney, since this whole court process has been going on, there's been 4 main cases I've been trying to give them between Leno, Bono, Emmerich, and Myers that we didn't touch on during my case. I gave my counsel all these governing cases to help mount our defense to be used. You know what I'm saying? None of them were really used, though. We went back and forth for months, asking my counsel to use this case and call C.O. Plotnick, which was the guy who strip searched me after I had got strip searched, who said I had no altered clothing under my pocket. Inspector Castle, who's the guy who originally sent the report to the MSP in his original incident report when he said Celia Hernandez's left hand was in my right pocket. I made my counsel aware of it, and yet he allowed the prosecution witness throughout the court case to say Hernandez's pants were down my pants or inside of my pants, which was untrue, and it wasn't. There was no objection to none of that. In all of these 4 governing cases I spoke on, Leno, Bono, Emmerich, Myers, these cases were threw out by the Supreme Court or the Court of Appeals or reversed and remanded because touching, grabbing, massaging over a clothed/covered groin area, the statute of gross indecency didn't apply to it. So what they did was they came up with a common sense society test, which is the Supreme Court, which is where they said gross indecency. There is no definition for what constitutes the act of gross indecency because of this lack of a clear understanding. Our Supreme Court has determined in order to rise to the level of gross indecency that we must use the common sense society test, and that would make the appropriate construction. Oral or manual sexual act committed without consent or with a person under the age considered any ultimate sexual acts committed in public. And when it comes to the masturbation in a public place, they consider an ultimate sexual act as masturbation of an exposed penis outside or underneath clothing, which neither was. More specifically in the Emmerich case, which was more fit to my case, which I told my attorney to bring up, was you had 2 defendants where one stuck their hand in the other defendant's pocket and rubbed back and forth, masturbating, massaging the groin area while applying pressure on the genitals, asking what the other liked. The Supreme Court said because both of the defendants consented to the acts, even in a public place, the touching of a clothed groin area of another, even in the public with a pocketed hand, does not constitute an ultimate sex act and did not amount to gross indecency. That was Peoples versus Emory. So these were all cases and things that I've been bringing up to my attorney during the whole thing that I would have helped mount our defense instead of coming in here. And so is it possible that this or that could have happened? Because I've always told her from the beginning, we're never denying her hand was in my pocket. All I'm saying is my groin area was covered by a fabric of my pocketed hand, which I've seen in these 4 cases get reverse remanded throughout by the Supreme Court of Appeals. And that's all I wanted to just get on the record, just for my appeal process. So thank you, man.
All right, Mr. LaFleur. So, Mr. Franklin, I thought brought all those cases up. We argued about them in his request for different rulings from the court. So that's all been preserved. I'm confident that that's all been preserved.
Your Honor, if I may.
Yeah.
Just for the record, to potentially save the court, I can't object to facts being put on my witness. Cross-examine them, but I can't object. As far as the cases, it's the attorney's job to read those cases, determine if those facts are on point with the case, and if they're not waste the court's time bringing them up.
So hold on, let him finish.
To insinuate that I'm not doing my job, let me put it into perspective. I am the attorney. I went to law school for 3 years. I did that while going through divorce, and it was one of the worst times of my life. So to insinuate that I would not put in the effort to do things when it's hard, that cuts to the core. That's a big part of who I am today. I looked at those. They were not on point. They were not NDOC cases. They did not pertain. They followed every avenue to try to get the result. It just wasn't possible.
All right. So what I was going with here, Mr.
Yeah, he kind of attacked his attorney there, and his attorney just came back. He's like, no, stop. That's not true. I did fight for you. Unfortunately, it just didn't work. I mean, for those of you that are struggling for what happened, I kind of said it in the intro. His, I don't know, girlfriend, female, companion, I don't know what their relationship is, but went to visit him in visiting area, put her hand down his in his pocket, and yeah, and that cost him 2 more years on whatever sentence he's already in jail for. That's what we're here for. Also, I did forget to warn you at the beginning. This is kind of graphic, definitely not safe for work. It's on the thumbnail, and in the title. I just forgot to put it in the intro. My bad.
I don't think there's any doubt that the issues that you think were applicable have been preserved. There's no doubt about that. Some reviewing court, if that's what you choose to do, can look at this and say, yeah, this court has got it wrong, and etc. Right? But I don't think they apply. We certainly heard arguments during the trial. What I think is most damning to you is the testimony of live witnesses who were involved in this act review, and the video. The video, I think, combined with the testimony, speaks for itself. There's no doubt that that video shows the woman in question that was with you, I don't recall her name off the top of my head, masturbating you in this public area, this visiting room. And the other thing about the video, it makes it undeniably clear there were other individuals there, not just Department of Corrections employees, but other folks in the visiting room. So, having said that, you can explore any appellate remedies that you would like, and we'll see what the reviewing court does with that. But getting to the work of today, which is proposing a sentence. Now, let me say this. Mr. LaFleur, you are before the court today. You have an extensive criminal history of 9 felonies prior to today. However, the good part that you have going for you, and nobody has even mentioned this today, is despite the fact that you've been incarcerated now since I think about 2015, you only have 34 Department of Corrections. You only have 34 misconducts. So that's 34 too many, but in the big picture, when I sentence people from the Department of Corrections, they often have dozens of misconducts a year, okay? Dozens of them. So General Department of Corrections inmate, looking at a specific appropriate sentence for you, you're kind of ahead of the game as it relates to your behavior in the prison. While not ideal and that we have misconducts, is better than what we see often, okay? Now, having said that, at some point you'll come up for parole, and I was looking at that earlier. I don't remember what your max was 20, 22, 27. I'll make the max sentence. We got I just saw this.
You trying to get what this maximum possible date is?
Yeah.
It is August 18th of 2039.
Okay, all right. Thank you. And I'm looking at 404 and I'm expecting it to see it there. All right, so that's what I'm looking for, sir. So you've got a maximum out date of August 18th of 2039, okay? You'll be eligible for parole way before that. That's the max date, okay? So my point was, where I want to go with this, you're going to come up before parole boards, and then when we talk about these misconducts, 34 of them, you are empowering strangers to make decisions for you about the rest of your life instead of you making those decisions, okay? So when you come before them with unclean hands, tickets, right? And now, unfortunately, a new conviction while incarcerated, it makes it really easy for them to say, well, Mr. LaFleur, why don't you go back, we'll flop you, and you can serve 2 more years, and you come back, we'll talk about that again, all right? I only mention that to you because, again, you have a sort of on the lower end of what we generally will see as far as misconduct. So you're somewhat better positioned than a lot of folks, okay? Now you have this new conviction. Now, what's an appropriate sentence for this new conviction? I watched the video. I saw what happened. In my mind, I believe the evidence is very clear what went on, all right? Now, I know you have some legal arguments about, well, if I'm not participating, if it's her, is that a crime? All that stuff. It's not for the court to consider today. You've been convicted of this. But what I do think about when I look at this, and I think of the video, did you put the community at risk as a result of this behavior? No. Did you put the facility at risk as a result of this behavior? Well, maybe. I think argument can be made when we have that sort of open display of sexual act that could put the officers involved at risk. It could put other people in that room at risk. But I know that didn't occur, right? At the end of the day, this ends, and as far as I could tell from the video, If other people were noticing, they certainly avoided making it obvious that they were noticing. No officers were involved or with a confrontation or a fight with you, anything like that, okay? So it's just a really poor decision made by you to allow that to go on, and made by the other individual involved to start doing it. I mean, it just kind of defies common sense that you would think in a visiting room full of people that we could get away with that and nobody's gonna know, right? In an ideal world, we would follow the rules. That'd be one. In an ideal world, you can get away with it and nobody notices. That'd be two, though not a great outcome. And then number three is where we're at today. You got caught. It is a crime. You're already an inmate with the Department of Corrections. And so here we are fashioning or factoring in all of those things when I impose what I think is an appropriate sentence. As it relates to possession of drugs, cell phones, all the other stuff that I think really endangers a facility, the people that work there, the people that reside there, this isn't that. When I think of assault on staff, hitting, spitting, all of that, this isn't that either, okay? I am required, Mr. LaFleur, to impose a $68 state cost. I'm gonna do that. I'm also required to impose $300 and, I'm sorry, $130 as a crime victims assessment. That's also required by statute. There will be $300 in court costs and $400 in attorney fees. And then as it relates to the sentence, the court's gonna impose 9 months with the Michigan Department of Corrections to statutory max of 15 years. You will receive credit for, I'm sorry, you will not receive credit for any time that you've previously served pursuant to statute, and this sentence that the court is imposing must be run and served consecutive to any term that you are currently serving. So 9 months, 15 years consecutive to any term you're currently serving, and no credit for time you previously served. Now, you do have a right to seek appellate review. Obviously, we've talked about that ad nauseum. This appellate paperwork is going to go into the file. You're going to have a copy to take back for your records. Now, if you want to pursue appellate review of the sentence, you have 21 days from today's date to make that request. And then if you want to request court-appointed counsel, you have a broader window of 42 days. So 21 and 42. Again, that paperwork's going to go back with you. Mr. Franklin, anything else? No. All right, Mr. LaFleur, you're all set, officers. Thank you today.
All right, that's it. Just a little court to get your Thanksgiving started. Yeah, this one was weird, and hopefully you guys saw it my way and kind of couldn't help but to chuckle a little bit. I mean, he came with his defense, right? Citing Supreme Court cases where this kind of thing were thrown out. Yeah, man, you got to make smarter decisions. He got 9 months for it. You know, hopefully that hands-on approach was worth the 9 months. All right, that's all I got. Hopefully you guys enjoyed this. If you did, please hit that like button. I would surely appreciate it. Until next time, bye.